International law, as many of my fellow scholars will tell you, is fascinating. It's a vibrant and dynamic field that touches upon every aspect of our globalized world. And yet, despite its importance, it remains somewhat underappreciated in the eyes of the general public. But when we dive deeper into this subject, it becomes clear why so many of us are captivated by it. The study of international law, while rooted in theoretical frameworks and jurisprudential debates, finds robust application across a diverse range of practical fields. These fields often require a nuanced understanding of both the substantive rules of international law and the procedural mechanisms for their implementation and enforcement. A scholarly examination reveals the intricate interplay between legal principles and real-world challenges. One significant practical application of international law is in the area of international dispute settlement. When states disagree on matters of international concern, they often turn to legal mechanisms to find peaceful resolutions. At the core of this field lies diplomacy, which includes both bilateral and multilateral discussions. Scholars analyze the effectiveness of various diplomatic strategies and the role of power dynamics in shaping negotiation outcomes. Bilateral diplomacy, often conducted through direct talks between two states, is a common first step in resolving disputes. For instance, the ongoing negotiations between Iran and world powers over the Iranian nuclear program exemplify bilateral diplomacy in action. On the other hand, multilateral diplomacy involves more than two states and can take place within established international organizations like the United Nations or in ad hoc settings, such as the recent climate conference in Egypt. Scholars examining this area investigate the complexities of these processes, including the strategies employed by states and the challenges they face. Another essential aspect of international dispute settlement is arbitration. Unlike judicial settlement, which involves litigation in international courts, arbitration is a private and consensual process. States voluntarily submit their disputes to an independent third party, known as an arbitrator, or an arbitral tribunal for a binding decision. Scholars working in this field focus on several key areas. They study the development of international arbitration law, paying close attention to how legal principles are applied in practice. One crucial aspect is the enforcement of arbitral awards, which can sometimes be resisted by states. Scholars analyze the mechanisms and challenges associated with enforcing these decisions, contributing to a better understanding of the effectiveness of international arbitration. Additionally, there is a growing body of scholarship examining the role of international arbitration in resolving complex commercial and investment disputes. As global trade and investment continue to rise, the demand for efficient and impartial dispute resolution mechanisms grows. In contrast to these more informal methods, judicial settlement involves bringing disputes before international courts and tribunals. Central to this field is the International Court of Justice, also known as the World Court, which is the principal judicial organ of the United Nations. The ICJ's primary function is to settle legal disputes submitted to it by states. However, the court's jurisdiction is limited by several factors, including the willingness of states to accept its authority and the nature of the disputes brought before it. Complementing the ICJ are numerous specialized international courts and tribunals. For instance, the International Tribunal for the Law of the Sea is responsible for resolving disputes concerning the interpretation and application of the UN Convention on the Law of the Sea. Scholars in this area examine the jurisdiction, adjudicative competence, and enforcement mechanisms of these courts and tribunals. They also analyze the interpretation of international law in specific contexts and the impact of international legal principles on global politics. A closely related practical application of international law is in the realm of international criminal law. This dynamic field focuses on holding individuals accountable for serious international crimes such as genocide, war crimes, crimes against humanity, and the crime of aggression. A significant aspect of international criminal law is jurisdiction, which refers to the legal authority of courts to hear cases and issue binding judgments. Scholars examine how international criminal courts exercise jurisdiction over individuals, particularly when those individuals have committed crimes in their own countries. The challenge of prosecuting powerful individuals who often enjoy immunity is also a subject of intense scholarly inquiry. Several international and domestic courts play crucial roles in this area, The International Criminal Court, based in The Hague, is a permanent court with jurisdiction to prosecute individuals for the most serious international crimes. Regional courts such as the European Court of Human Rights and the Inter-American Court of Human Rights also contribute to the development and enforcement of international criminal law. Scholars closely monitor the ICC's activities, analyzing its effectiveness and the challenges it faces in gaining the cooperation of states. Within international criminal law, international humanitarian law, or the law of armed conflicts, holds a prominent place. IHL is a set of rules designed to regulate the conduct of armed conflicts and protect civilians caught in hostilities. Scholars in this area analyze the application of IHL in contemporary conflicts, examining how states and non-state armed groups comply with its principles. The Red Cross and other humanitarian organizations play vital roles in monitoring IHL compliance and providing assistance in conflict zones. With the rise of new conflicts and non-state actors, the field of IHL is constantly evolving, prompting scholars to examine how existing rules apply to novel situations. Another important practical application of international law is in the area of international human rights law. This field focuses on safeguarding the fundamental rights and freedoms of individuals worldwide. Scholars in this area cover various aspects of international human rights law, including monitoring and reporting, advocacy, and litigation. Let's delve into each of these. First, monitoring and reporting involve analyzing the work of international human rights bodies, such as the UN Human Rights Council and treaty monitoring committees. These bodies regularly review the human rights situation in different countries and make recommendations for improvement. Scholars study these reports, assessing the effectiveness of international mechanisms in promoting and protecting human rights. Second, advocacy and litigation are also crucial in advancing international human rights law. Scholars examine how non-governmental organizations and other actors advocate for human rights at the international level. Additionally, they investigate the use of litigation as a tool for holding states accountable for human rights violations. This includes bringing cases before international courts and tribunals, or utilizing domestic courts to address international human rights norms. Another critical aspect of international human rights law is implementation and enforcement. Scholars in this area explore the challenges associated with implementing international human rights norms at the national level. They analyze how states incorporate international human rights obligations into domestic law and the effectiveness of various implementation strategies. Moreover, there is a growing body of scholarship examining the enforcement mechanisms available to international human rights law. This includes the role of international organizations, non-governmental actors, and the increasing use of litigation in holding states accountable for human rights violations. As globalization and international trade continue to grow, the importance of international economic law becomes increasingly evident. This field covers a wide range of topics, including international trade law, investment law, and financial law. Let's break down each of these areas. First, international trade law. The rules governing international trade are primarily embodied in the agreements of the World Trade Organization. Scholars in this area examine the WTO's agreements, dispute settlement mechanisms, and the broader implications of these rules for international trade. The WTO's dispute settlement body plays a crucial role in resolving trade disputes among member nations. Scholars analyze the effectiveness of the DSB in settling disputes and the impact of these rulings on global trade flows. Additionally, there is a lively debate regarding the balance between the liberalization of trade and the need for states to pursue other policy objectives, such as protecting the environment or promoting human rights. Scholars grapple with these tensions, exploring how international trade law can adapt to changing global priorities. Second, international investment law. As foreign direct investment continues to rise, the need for a clear legal framework becomes increasingly important. International investment law governs various aspects of cross-border investments, including the protection of investors and the settlement of investment disputes. Scholars in this area examine the legal instruments governing foreign direct investment, such as bilateral investment treaties and regional agreements. One significant aspect is the investor-state dispute settlement mechanism, which allows investors to bring claims against host states for alleged breaches of their investment commitments. ISDS has been controversial due to concerns about its transparency and accountability. Scholars analyze the strengths and weaknesses of this mechanism, contributing to ongoing debates about its reform. Finally, international financial law. This subfield addresses the legal aspects of international monetary relations and financial regulation. Scholars in this area examine the rules governing exchange rates, international debt and banking, as well as the legal responses to global financial crises. The rise of cryptocurrencies and other innovative financial instruments also poses new challenges and opportunities for international financial law. As the global economy becomes more integrated, the effective regulation and oversight of financial institutions and markets become crucial. Scholars in this area contribute to the development of legal norms and principles that can mitigate risks and promote stability in the international financial system. The final practical application we will discuss is international environmental law. This interdisciplinary field combines elements of international law, environmental science, and policy to address pressing global challenges. Climate change, biodiversity, loss, and pollution are some of the most pressing issues tackled by this field. One crucial aspect is international environmental agreements. Scholars analyze the effectiveness of treaties and agreements such as the Paris Agreement on climate change in addressing global environmental problems. They examine how states negotiate these agreements, their subsequent implementation, and the challenges of ensuring compliance. Transboundary environmental disputes can also arise between states. International environmental law provides mechanisms for resolving these disputes peacefully. Scholars examine various methods of dispute resolution, including negotiation, mediation, and adjudication. They also explore the role of international organizations and courts in enforcing environmental rules and promoting cooperation among states. Furthermore, international environmental law increasingly emphasizes environmental justice. Scholars in this area examine the disproportionate impact of environmental degradation on vulnerable populations and advocate for policies that ensure equitable access to environmental benefits and reduce disparities in environmental burdens. These 5 practical applications: international dispute settlement, international criminal law, international human rights law, international economic law, and international environmental law, offer just a glimpse into the vast landscape of international law in action. Each of these areas highlights the dynamic and evolving nature of international law, demonstrating its crucial role in addressing contemporary global challenges. As scholars continue to explore these and other practical applications, the effectiveness and relevance of international law in shaping our world become increasingly evident. Thank you for watching this video. If you enjoyed it, please feel free to show your support. Your support helps to keep our content free and accessible to everyone. If you want to watch more videos like this, don't forget to subscribe. You can also stay up to date with all our latest content by following us on social media. Thank you again for watching, and I look forward to seeing you in the next video.